Good morning. My name is Hannah Mohammed. What I have prepared is a detailed investigative report examining the conduct of state actors, including that of Attorney General Mohabir Anil Nandalal and his central role in the extradition proceedings of opposition leader Azruddin Mohammed. Given the length and complexity and seriousness of the material, I have chosen to present it orally. This ensures that the key facts, timelines, and issues are clearly understood by the public rather than lost in a document that many may not fully read or interpret in context. This matter is of significant national importance, and it is essential that the information is communicated in a way that is accessible, structured, and accountable. I stand behind the context of this brief, and I will now present it. PPP employs 25 attorneys in the fight to extradite opposition leader Azruddin Mohammed, a state-backed show of full force. The central role of Attorney General Anil Nandalal in the Mohammed extradition matter. There is a standard by which the chief law officer of any democratic nation must be judged, not just whether his actions fall within a technical reading of the law, but whether his conduct, taken as a whole, reflects the impartiality, restraint, and dignity that the office demands. By that standard, Attorney General Mohabir Anil Nandalal has failed spectacularly, repeatedly, and in full public view. This is not a defense of Azruddin Mohammed against the charges he faces. Those allegations will be tested in a court of law. What follows is a documented account of how Guyana's Attorney General has, from the earliest moments Azruddin Mohammed indicated that he would enter the political arena, placed the full apparatus of the state at the service of one goal: to destroy him. First, let us consider the army of lawyers. Anil Nandalal, SC, Attorney General of Guyana, Minister of Legal Affairs, and legal advisor to the Guyana Elections Commission. 2. Terrence F. Williams, KC, Jamaica. 3. Herbert Mackenzie, Jamaica. 4. Celine Diedrich, Jamaica. 5. Glenn Hanneman, Portugal. 6. Douglas Mendez, SC, Trinidad and Tobago. 7. Darshan Ramdani, QC. 8. Clay Hackett, Trinidad and Tobago. 9. Nigel Hawke, Solicitor General. 10. Shoshana Lal, Deputy Solicitor General. 11. Arudranath Gasai, representing Principal Magistrate Lachman, where the state ought to be paying him as he is representing a magistrate in her official capacity. 12. Deshaun Prasad, AG Chambers Attorney. 13. Robin Stobie, SC. 14. Anand Ramlagan, SC, former Attorney General for Trinidad and Tobago. 15. Jared Jagru, Trinidad and Tobago Law Firm, LLC. 16. Jason Moore, GRA. 17. Sanjeev Datadin, PPP Member of Parliament. 18. Judy Stewart Adonis. 19. Maritha Haley, GRA. 20. Darshani Lal, GRA. 21. Fiona Hamilton, GRA. 22. Ornice Gordon, GRA. 23. Nicklin Belgrave, GRA. 24 and 25. Unnamed AG Chambers attorneys present at every proceeding in the court. The scale of legal firepower assembled against one private citizen, an opposition politician, is by itself rather telling. The prosecution team in the extradition matter includes Jamaican King's Counsel, Terrence F. Williams and his associates, Herbert Mackenzie and Celine Diedrich, alongside Guyanese attorney residing in Portugal, Glenn Hanneman, a figure whose own history demands scrutiny, which we will turn to shortly. In the GRA proceedings involving the Lamborghini importations, the state retained senior counsel Anand Ramlagan, former Attorney General for Trinidad and Tobago, alongside senior counsel Robin Stobie, PPP Member of Parliament Sanjeev Datadin, and a team of additional attorneys, including Maritha Haley, Judy Stewart Adonis, Jason Moore, Fiona Hamilton, Ornice Gordon, and Nicklin Belgrave. At the High Court level, Nandalal has personally led this team, flanked by Trinidad and Tobago Senior Counsel Douglas Mendez, Queen's Counsel Darshan Ramdani, and Solicitor General Nigel Hawke. There are a few more who are involved in various ancillary proceedings. This is better described as a legal team funded entirely by you, the Guyanese taxpayer, assembled against one man. Now, consider the lie that was told about it. Nandalal publicly stated that the Jamaican prosecutors were selected and approved by the United States, framing their presence as a product of U.S. direction. The Guyanese public was led to believe by Nandalal that Washington chose these lawyers. Then, a leaked memorandum from the Ministry of Home Affairs surfaced, dated November 3, 2025, bearing the signature and stamp of Permanent Secretary Andre Ali, explicitly authorizing a wire transfer of $62,558 US to Williams and his team for services rendered in, quote, the case of the Guyana Police Force versus Nazar Mohammed and Azruddin Mohammed. The document was unambiguous. Guyana selected, retained, and paid these lawyers. Additionally, a representative from the U.S. Embassy in Guyana, corroborated by another representative from the U.S. State Department of Justice, stated that the United States played absolutely no role in selecting, hiring, and paying the legal services of the Jamaican attorneys. Nandalal was forced to walk his position back, acknowledging that Guyana is the country which bears the costs as the requesting state, a complete reversal of the narrative he had sold to the public. With the very limited financial information leaked to the public, billions of dollars of Guyanese taxpayers' money has reportedly been channeled into this pursuit across its various components. Whatever the precise figure, the breadth of the legal apparatus alone tells a damning story. This is not how states respond to routine extradition requests. Let's talk about public commentary and issues in the news, prejudicial statements. Nandalal hosts a regular television program called Issues in the News, a platform that, in a functional democracy, might serve as an avenue for public legal education. In Nandalal's hands, it has operated as something closer to a prosecution chamber without a defense table. It has operated as a record of his commentary on the Mohammed case, which is extraordinary in its prejudice. According to court documents submitted in the Mohammed's judicial review proceedings, the defense cited 15 separate public statements made by senior government officials, including Nandalal, publicly portraying the Mohammeds and opposition leader Azruddin Mohammed as criminals before any judicial determination. Among those statements, one attributed directly to Nandalal during his program was quoted in court submissions as, "The person is a criminal already." Those are not the words of a neutral law officer managing an extradition request on behalf of the foreign state. Those are words of a prosecutor who has already rendered his verdict. In addition to proclaiming guilt, Nandalal has used the program to repeatedly criticize the pace of proceedings before the magistrate, a sitting judicial officer, and has complained publicly about what he calls deliberate delay tactics by the defense. He has characterized defense applications as proceedings intended to delay, called constitutional challenges frivolous and vexatious, and accused the defense of deploying fabricated medical explanations. He even suggested the entire proceeding was being sabotaged. This running and repeated commentary, broadcast nationally while the matter is actively before the courts, constitutes interference with live judicial proceedings by the state's own chief legal advisor. That he has done so repeatedly without restraint and without apparent concern for the appearance of bias is a matter of public record. Venezuela narrative, allegations, and international response. Perhaps no element of this case is more revealing of the government's methods than the Venezuela narrative, a campaign of deliberate misinformation bankrolled by the Guyanese treasury and deployed during an active election campaign. Nandalal repeatedly and publicly alleged that Azardin Mohammed had connections to Venezuelan President Nicolas Maduro, that he was, in the language that spread across social media and regional news wires, a pro Maduro puppet. These false claims were designed to associate a Guyanese presidential candidate with a foreign authoritarian at the precise moment when Guyana's territorial dispute with Venezuela was highly politically charged. Other senior government officials who were part of the state machinery used to peddle the false narrative included the President of Guyana, Mohamed Irfan Ali, Minister of Foreign Affairs, Hugh Todd, Minister of Home Affairs, Wanij Waldron, Minister of Sports, Youth and Culture, Charles Ramsden Jr., and Minister within the Ministry of Finance, Dr. Ashni Singh, and also Vice President Bharat Jagdeo, who was investigated for allegations of massive bribery and corruption following a 2022 Vice News investigation. The award-winning documentary titled Guyana for Sale exposed evidence linking Jagdeo to claims made by Chinese businessman Su Zhirong that he accepts bribes. The truth of this false narrative was ultimately demolished not by Mohammed's own denials, but by the Venezuelan government itself. Venezuela's ambassador to Guyana, Carlos Amador Perez Silva, denied these accusations. There was no collusion, no coordination, no evidence of any kind linking Mohammed to Maduro's government. Foreign lobbying and FARA filings, Continental Strategy Communications. How are these claims manufactured? Well, documents filed with the United States Department of Justice under the Foreign Agents Registration Act, FARA, provide the answer. On June 23, 2025, John Barsa, a partner at Continental Strategies LLC, a lobbying firm contracted by the government of Guyana, sent an email to Roberto Laguna's communications director for Republican Congressman Carlos A. Gimenez of Florida with 5 draft tweets. The email was sent explicitly on behalf of the government of Guyana. The draft tweets referred to Mohammed as a sanctioned Maduro ally, a pro-Maduro puppet, and warned that his presidential candidacy was Venezuela's latest attempt to creep into a sovereign democracy. 5 days later, Congressman Gimenez published a version of those tweets on X, Twitter, amplifying the false narrative to an international audience. The government's contract with Continental Strategy was signed in December 2024. Its stated purpose, per the FARA filing, were to increase U.S. trade and investment, address financial sector improvements, and enhance Guyana's international profile. Nowhere did the mandate authorize the targeting of a domestic political opponent, the fabrication of a foreign policy threat, or the manipulation of a sitting U.S. congressman's social media presence during a Guyanese election campaign. President Ali claimed ignorance when confronted by journalists. Vice President Jagdeo admitted the tweets came from Continental Strategy, but denied the government directed them, while simultaneously vouching for their credibility. Nandalal said nothing on the matter. The Guyanese taxpayer funded a lobbying campaign designed to destroy the reputation of a presidential candidate on the international stage using fabricated foreign connections. During the consideration of budget estimates on February 10, 2026, at approximately 4:15 p.m. in the Parliament of Guyana, it was disclosed that taxpayers are paying a combined 90,000 US dollars per month, with Guyanese 269,500,000 allocated for advocacy services to lobbyist firms. During that session, MP Amanza Desir and opposition chief whip Tabitha Sarabo Haley pressed the Minister of Foreign Affairs Hugh Todd to justify this expenditure, questioning what tangible benefits the Guyanese people are receiving in return for such a significant outlay of public funds. Minister of Foreign Affairs Hugh Todd confirmed that 3 lobbyist firms had been contracted under the relevant budget line item, with 2 currently retained, DR Consultancy and Continental Strategy. According to the minister, DR Consultancy receives $8,320,000 per month, while Continental is paid $10,400,000 per month. These contracts have since been renewed, the expenditure continues, and the purpose has never formally changed. And yet, the pattern of output targeting Mohammed specifically has been undeniable. Legal terminology and public misrepresentation, indictment, and fugitive claims. Nandalal has, throughout this charade, deployed legal terminology in a manner calculated to terrify Guyanese who may lack legal training rather than to inform them. The term indictment has been wielded as if it represents a finding of guilt. It does not. An indictment in the United States federal system is a formal charging instrument used by a grand jury, which requires only probable cause, a reasonable belief that a crime may have been committed. It is explicitly not a verdict. Grand jury proceedings are one-sided by design. Only the prosecution presents evidence. The threshold is low by deliberate legal policy because the trial itself is where guilt is tested. Nandalal knows this. He is a senior counsel. That he has allowed and at times encouraged the public conflation of indictment with conviction is a deliberate choice. The real test comes later in court, where the standard is much higher, proof beyond a reasonable doubt. That is when evidence is tested, challenged, and examined by both sides before a judge or jury reaches a decision. A well-known phrase often cited in legal commentary is that a grand jury would indict a ham sandwich. This quote is commonly attributed to former New York Court of Appeals Chief Judge Saul Watchler, and it is used to illustrate how low the probable cause threshold can be understood in practice when only one side of the case is being presented. Anil Nandalal repeatedly threw around the word indictment to the Guyanese populace and wielded it as a weapon to frighten and to trick them into thinking that this was already a conviction. Similarly, the characterization of Azrin Mohammed as a fugitive offender has been deployed with rhetorical relish. Nandalal has proclaimed that publicly and repeatedly, yet the Fugitive Offenders Act, under which these proceedings are being conducted, defines the term in technical legal terms related to persons subject to an extradition request. It is not a moral judgment of flight or guilt. The Mohammeds surrendered themselves when required. They were granted bail and have consistently appeared before the court. They are not fugitives in any ordinary sense of the word. The legal term is being stretched beyond its colloquial meaning to ensure maximum public prejudice. Extradition framework and treaty context. Nandalal's proclamations about Guyana's legal obligations under the extradition treaty, drawn from independence, have similarly been used to foreclose any public discussion of whether those obligations are being discharged in a procedurally fair manner. The amendments of the Fugitive Offenders Act in 2009 and again in 2024, amendments that the defense has challenged as constitutionally suspect, were passed under the PPP government. Nandlal, as minister responsible, has a personal interest in their validity. His public defense of those amendments, while simultaneously attacking lead counsel in proceedings that depend on them, represents a conflict that he has never acknowledged. Selection of prosecution counsel Glenn Hanneman. Of all the attorneys the government could have retained to prosecute this case, the selection of Glenn Hanneman as counsel for the prosecution deserves particular scrutiny. Hanneman is a Guyanese attorney residing in Portugal, who previously represented Shahid Roger Khan, convicted in a U.S. federal court in Brooklyn for cocaine trafficking, witness tampering, and related offenses. His connection to the Khan case does not end at legal representation. In the prosecution of Khan's New York attorney, Robert Simels, who was convicted on multiple counts of conspiracy to obstruct justice through witness tampering, Judge John Gleeson of the United States District Court for the Eastern District of New York made a specific finding. According to court records affirmed by the U.S. Second Circuit Court of Appeals, Glenn Hanneman was identified by Judge Gleeson as a member of the conspiracy to obstruct justice in the Simels proceedings. This is a matter of public record preserved in U.S. federal court decisions, and this is the individual that you are to believe Anil Nandalal chose to place before the magistrate to represent the interests of the United States government in the extradition of Guyana's elected opposition leader. During proceedings in February 2026, Hanneman referred to Azruddin Mohammed in open court as the biggest criminal from the bar table, prompting defense counsel to immediately apply to have him banned from the proceedings on grounds of prejudicial bias. The magistrate requested written submissions on the matter. Diplomatic note and arrest sequence, October 30th and 31st events. Now, consider this aspect of the case. On October 30th, 2025, a diplomatic note number 417, carrying the U.S. extradition request for the Mohammeds, arrived at the Ministry of Foreign Affairs after official hours. This was the testimony of Permanent Secretary Sharon Rupchan Edwards, herself the prosecution's lead witness. What happened next was not standard procedure. Rather than follow the normal administrative routing process, Rupchan Edwards testified that she personally took the documents at night directly to Minister of Home Affairs Wanij Waldron on the night of October 30th, 2025. Rupchan Edwards testified that she could not recall most of the details of the delivery of the diplomatic note, including a basic description of the marshal who delivered said note, as well as the details of the delivery to Minister Waldron that night. By the following morning, October 31st, the authority to proceed had been signed, arrest warrants had been issued, and more than a dozen heavily armed and masked gunmen who were not clothed in police uniform jumped the presumptive opposition leader on a public street in what was widely reported as a public spectacle. The younger Mohammed was handcuffed and thrown in the back of a pickup truck after being manhandled, then paraded through the streets of Guyana's capital, Georgetown, while the elder Mohammed was placed in the back of a car and taken to the police station. Now let's compare that to the case of Ronley Floyd Bino. The speed of issuing the authority to proceed was, to use the defense counsel's word, breakneck. Compare it to the case of Guyanese national Ronley Floyd Bino, whose extradition request arrived in early November 2025 and did not reach the magistrate's court until February 2026. It should also be noted that Bino's extradition request was hidden from the public and only revealed by witness testimony during cross-examination in the Mohammed case. For months, that request sat, following normal administrative channels. Nandalal, it should be noted, had been making public comparisons between the two cases, repeatedly pointing to Bino, who chose not to contest his extradition, as a model of how the process should unfold, while condemning the Mohammeds' legal challenges as obstruction. What Nandalal did not mention publicly was the striking discrepancy in how the two cases were handled administratively. It took the Mohammeds' own legal team to expose this in open court proceedings, forcing the comparison into the public record. Let's talk about the chain of custody challenges and the procedural fairness. The chain of custody of the actual extradition documents has also been contested. Defense attorney Cian Dorjan argued in court that the documentary evidence was fundamentally flawed. The prosecution's own witness, Rupchan Edwards, handed over the documents never to be seen again, appearing in court for the first time to identify paperwork she could not establish had remained unaltered. Not even in a trivial narcotics case would this be permissible, Dorjan told the court. Now, the Attorney General's involvement in the authority to proceed and advisory role. Nandalal, who has pronounced publicly on the guilt of the defendants, advised on the authority to proceed. The Attorney General is simultaneously a legal commentator, a strategic advisor to the prosecution, and an active participant in public proceedings, all while running a television program condemning the defendant. The Attorney General has admitted on his program that he receives a report at the end of every court hearing detailing what takes place in the case, and that he is aware of the correspondences, among other matters. He has also stated on his program that he assisted in the preparation of the authority to proceed, and that he advised the Minister of Home Affairs, Wanij Waldron, on the extradition law generally. The defense's case is that this constitutes a clear tainting of the process, resulting in the authority to proceed being issued without proper checks and balances, without adequate consideration of the protections afforded to the requested persons, and with a blatant disregard for the applicable law and the responsibilities attached to the office. They argue that this level of malice introduced bias into the issuance of the authority to proceed to such an extent that it rendered it void ab initio. Now let's talk about the alleged pre-political pressure and warning claims. Guyanese, we all know this started long before these proceedings, before any warrant was issued, before any extradition request had been made, before Azruddin Mohammed had filed a single piece of paper with the Guyana Elections Commission. There was a conversation. Azruddin Mohammed has stated publicly and consistently that before any official proceedings were initiated, there were messages brought by emissaries from President Mohammed Irfan Ali, Vice President Bara Jagdeo, and Attorney General Anil Nandlal that if he did not make a public announcement declaring that he would not enter politics and would not seek the presidency, that consequences would follow. Specifically, he was told by Nandlal that GRA agents would be dispatched to seize his vehicles. Both Jagdeo and Nandlal denied the claims. Then, out of the blue, after 4 years, GRA agents came for the vehicles. Let's talk about that. GRA enforcement actions and vehicular seizure incident. On April 5th, 2025, GRA officers arrived at Mohammed's residence without any legal documents to seize a fleet of luxury vehicles belonging to the Mohammed family, citing over $1.2 billion in alleged unpaid taxes related to false declarations under the remigrant scheme. A crowd gathered. A tense standoff ensued. 2 separate virtual hearings were convened before Justice Gino Prasad that same day, and a temporary restraining order was granted, halting the seizure. GRA vowed to press on. The court battle over the vehicles has continued as a subsidiary front in the broader campaign against Azruddin Mohammed. That the threat was made and then the threatened action followed is not disputed. What is disputed is who ordered it and why. What is observable is the sequence: political ultimatum, political figure enters the race, state machinery mobilized. Let's talk about the ministerial role, Wanij Waldron, and her public statements. Minister of Home Affairs Wanij Waldron, who signed the authority to proceed on the night of October 30th, 2025, spent the 2025 election campaign actively and publicly vilifying Azruddin Mohammed. She made repeated prejudicial statements before Guyanese at rallies, advancing the Venezuelan connection narrative, the false narrative about the presidential candidate Azruddin Mohammed and alleged connections to Nicolas Maduro, and warning the public of the supposed dangers of Mohammed's candidacy. Her comments against Azruddin Mohammed are documented in the defense's own court submissions. She has been cited as among the government officials who had publicly portrayed the Mohammeds as criminals before any judicial finding. She is also the minister whose administrative decision to issue the ATP was challenged as bias. The defense argued that no reasonable person could regard a PPP cabinet minister, one who had personally campaigned against Mohammed and made public statements prejudging him as a neutral administrative actor capable of issuing a procedurally fair ATP. The argument was not legally frivolous. It was constitutionally serious. The speed of proceedings and constitutional questions. What is really interesting, though, is not just the outcome, but the speed at which it was reached. These were not simple procedural matters. They raised serious constitutional questions about bias, about due process, and about the separation between political actors and administrative functions. They were resolved in an expedition that stands in sharp contrast to the glacial pace at which other constitutional challenges routinely move through Guyana's courts. The legal proceedings present only one dimension of what has been deployed against Azruddin Mohammed. The full breadth of state machinery has been brought to bear on every element of his existence. Let's talk about the broader state machinery deployment against opposition leader Azzuddin Mohammed. The Guyana Revenue Authority initiated tax enforcement proceedings and vehicle seizures. The Maritime Administration Department issued directives effectively restricting the movement of the Mohammed's vessels along Guyana's coast, ending their ability to conduct coastal voyages and ceasing another one of their business operations. Local airlines were given directives restricting Azzuddin Mohammed's movement within his own country. Banking relationships collapsed under the weight of the OFAC sanctions, sanctions that, as Nandalal and other officials well know, apply to U.S. persons and U.S. entities engaging with sanctioned individuals, not to Guyanese citizens conducting domestic and local business with other Guyanese. The weaponization of those sanctions by the PPP government and state actors against a man's standing within his own country, where the Treasury Department's reach does not formally extend, has been methodical and deliberate. Business operations were effectively frozen. Financial flows were strangled. The GRA cases, the extradition proceedings, the constitutional challenges, the lobbyist campaign, the nightly issues in the news condemnations, these did not happen independently. They formed a coordinated pattern, calibrated to break a man financially, cripple him reputationally and politically before he could consolidate the popular support that was evidently frightening the government badly enough to deploy all of this in the first place. Let's talk about media state communications and public perception. PPP aligned media outlets serve as amplifiers. Independent and critical media houses were condemned. State media was fully mobilized. The government's network of propaganda machinery was activated. Nandalal's program functioned as a nightly clearinghouse for government talking points on the case. Its host, simultaneously the nation's chief law officer, lead prosecutor, and social media commentator, roles that in any jurisdiction that takes the administration of justice seriously are understood to be incompatible. The legislative framework of the Fugitive Offenders Act amendments. Nandalal has also moved legislatively. Amendments to the Fugitive Offenders Act passed in 2009 and again significantly in 2024 have shaped the legal terrain under which these proceedings are being conducted. The 2024 amendments were enacted after Azzuddin Mohammed had already been sanctioned and before the extradition request arrived. Whether those amendments were designed in anticipation of this specific case is a question that Nandalal, as the minister responsible, has declined to answer publicly without any candor. The defense challenged those amendments as unconstitutional. The High Court struck down one provision while upholding the others. The substantive constitutional question whether amendments rushed through by the very government seeking extradition can be legitimately applied in proceedings that the government is driving has not been fully resolved. The concluding assessment, allegations of systemic bias. The record, assembled and set out above, is not one of a neutral law officer faithfully discharging Guyana's international obligations. It is a record of personal involvement at every stage, prejudicial public commentary throughout active proceedings, deployment of state agencies as enforcement tools in a political campaign. Payment of taxpayer funds to foreign lobbyists to fabricate a foreign policy threat around a domestic political opponent. Selection of prosecution counsel with a documented history in obstruction findings, and advice rendered in the very administrative process the state is now relying upon in court. The Attorney General should never be in a position where he faults citizens of this country for pursuing their constitutional rights, to question proceedings, to raise lawful objections, and to pursue due process. Under the Constitution, a citizen must have protection under the law. Anil Nandalal has not destroyed his credibility through any single act. He has done it systematically. In the high-profile case involving elected opposition leader Azharuddin Mohammed, significant public concern persists regarding political motivation, fairness, and the integrity of the process. This is set against the backdrop of a government that has deployed every arm of the state and spared no public resources in what is widely viewed as a highly politicized and politically motivated matter. The case resumes before the Apex Court, the Caribbean Court of Justice, CCJ, in Trinidad and Tobago on April 21st, 2026. The purpose of this submission is to present relevant facts and context in a structured manner for public information and awareness, as this is an extremely public matter in respect of which substantial public concern exists regarding political motivation, fairness, and the integrity of the process, so that the full picture of events may be understood holistically rather than in fragmented form of the extradition proceedings of the opposition leader of the Cooperative Republic of Guyana, Azharuddin Mohammed. Thank you.